Imagine that na sweldo mga kababayan, 300,000 tapos hindi man po nagre-report sa trabaho. Si Bato dapat yung yung sweldo ni Bato, wag nang ibigay. May proposal po si Ping Lacson, i-hold yung sweldo ni Bato de la Rosa kasi hindi man siya nagtatrabaho. At dapat mga kababayan, if I may add, sana doon sa period of amendments, hindi lang po members ng Congress, pati yung mga nasa executive tulad ng Vice Presidente. Si Sara hindi man nagtatrabaho. Mga kababayan, sige lang ikot kung saan-saan. Kasama pa yung gwardiya niya. Tapos charge lahat. Yung gastos mga kababayan, yung sweldo. Kahit sabihin pa ng mga kababayan ni Sara na yung gastos niya daw sa travel, hindi charge sa gobyerno. Just the same, yung panahon niya na imbis ginugugol mga kababayan sa paglilingkod sa ating mga mamamayang Filipino, ginugugol niya sa kanyang tatay. Mabuti naman po yung kalagayan ng kanyang tatay. So sige lang ang travel ni Sara Duterte. So dapat pag ganyan, mga kababayan, walang sweldo. Hindi siya kukubra ng sweldo pag hindi siya rumireport sa opisina. Dapat may DTR. Hello po mga kababayan, si Dante Maravillas. O yung mga hindi nagtatrabaho sa Congress at saka sa Senado, mga senador na hindi na makapagtrabaho kasi nagtatago, tapos kayo ngayon. Bakit na niya, Mr. Maravillas? May final mga kababayan na panukalang batas si House Majority Leader Sandro Marcos na dapat daw no work, no pay para sa mga members ng Congress. Pag sinabi mong members ng Congress, kasama dyan yung Senado. Kasi ang Congress of the Philippines po, ang composition po, the House of Representatives o lower house at saka yung upper house, the Senate. Ito yung balita ngayon, mga kababayan sa GMA News, no work, no pay para sa mga congressman. Mali yata, hindi lang mga congressman. Basahin, House Majority Leader Sandro Marcos, inihain ang House Bill 7432 o panukalang no work, no pay for Members of Congress Act. Tama po ito. Dapat noon pa ito, mga kababayan, ipinasa. Kaya lang walang nag-isip ng ganyan. And maybe, nakita mga kababayan, siyempre ni Sandro Marcos, masyado niyang maraming members ng Congress, lalo na sa House of Representatives po. Tulad ni Pulong. Hindi manaros, nagre-report mga kababayan sa Kongreso. Laging sarado. Nung pumasyal kami ni Mrs. doon sa Congress, tinuro sa akin ang kasama naming vlogger. Ito niya yung opisina ni Pulong. Alos niya, pinamamahayanan ng gagamba. What? Maalikabok na niya yung table. Lagi niya yan sarado. Hindi man na niya pumupunta dyan. You see, maraming ganyan na mga members ng Congress. So tama lang ito. At ngayon, senador. Kasi si Bato de la Rosa nagtatago. Until today, hindi man nagre-report sa kanyang opisina. Hindi pa bumabalik. Grabe takot ni Senator Bato. Nang i-announce ni Boyeng Rimulya, may warrant of arrest na niya. So, with that, this is timely, mga kababayan. Ayan Sandro Marcos, isinusulong no work, no pay policy sa mga miyembro ng Senado, Kamara. Ayon kay Marcos, layo ng kanyang panukalang no work, no pay for Members of Congress Act na iayon ang kompensasyon ng mga mambabatas sa aktwal nilang pagganap sa tungkulin. Sa kasalukuyan, tumatanggap ng humigit kumulang 300,000 buwanang sahod ang mga senador at kongresista. Imagine that na sweldo mga kababayan, 300,000 tapos hindi man po nagre-report sa trabaho. Si Bato dapat yung sweldo ni Bato, wag nang ibigay. May proposal po si Ping Lacson, i-hold yung sweldo ni Bato de la Rosa kasi hindi man siya nagtatrabaho. At dapat mga kababayan, if I may add, sana doon sa period of amendments, hindi lang po members ng Congress, pati yung mga nasa executive tulad ng Vice Presidente. Si Sara hindi man nagtatrabaho. Mga kababayan, sige lang ikot kung saan-saan. Kasama pa yung gwardiya niya. Tapos charge lahat. Yung gastos mga kababayan, yung sweldo. Kahit sabihin pa ng mga kababayan ni Sara na yung gastos niya daw sa travel, hindi charge sa gobyerno. Just the same, yung panahon niya na imbis ginugugol mga kababayan sa paglilingkod sa ating mga mamamayang Filipino, ginugugol niya sa kanyang tatay. Mabuti naman po yung kalagayan ng kanyang tatay. So sige lang ang travel ni Sara Duterte. So dapat pag ganyan, mga kababayan, walang sweldo. Hindi siya kukubra ng sweldo pag hindi siya rumireport sa opisina. Dapat may DTR, daily time records. Yung ordinary employees mga kababayan ng ating pamalaan, may DTR. Pagkatapos kayo, wala kayong DTR. Ano yan? Sasabihin ninyo, justify ninyo. Nag-iikot-ikotan niya. Nag-iikot-ikot nga. Pero anong ginagawa ninyo pag iikot-ikot? Si Sara halimbawa, nag-iikot-ikot, lahat man para sa interes ng kanyang tatay. Tapos kasama sa pag-ikot-ikot yung sumama sa rally ng maisog noon. Nag-iikot-ikot para sa destabilization. Di ba? So dapat po sa period of amendments, kung hindi kasama dito sa proposal po ni Sandro, idagdag na dapat yon. Hindi lang members ng Congress, pati yung mga nasa executive and all officials ng ating gobyerno. Sakop dapat, no work, no pay. Lugi po yung ating mga mamamayang Filipino and the ordinary employees of government. Maigpit sa kanila. Pagdating dito sa mga elected officials, masyadong maluwag yung batas. Kaya namimihasa mga kababayan. Nakakapang-abuso. Di ba po? So sabi ni Sandro Marcos, this has led to public concern over absenteeism, lack of accountability in wastage of taxpayers' funds. Payag ni Marcos. Sa ilalim ng panukala, ibabatay ang sahod ng mga mambabatas sa kanilang pagpasok sa plenary sessions, pagdalo sa committee hearings at iba pang opisyal na gawain sa Kongreso. Talaga niyang tinatarget niyan yung mga Duterte, lalo si Pulong. Niya naman kung yun ang target talaga po, totoo naman po. Ilang beses ba pumasok sa Congress si Pulong at nag-participate sa mga committee hearings? Nakita lang natin si Pulong nung opening ng Congress. Hindi na natin nakita yung kaluluwa. Nakita natin kung saan-saan pumupunta. Nandun din kasama, nagtatagpo sila doon ni Sara sa Dahig. Diba? Loging-logi ang ating mga mamamayan sa pagpapasweldo sa kanila. So dapat maging base, sabi dito sa panukalang batas ni yung mga committee hearings. Tulad nito, babad yung mga congressmen noon sa Quadcom sa mga investigation. Habang si Pulong babad sa sa beer house. Nakita ninyo yung inaamba niya ng saksak yung isang sabi bugaw yon. Doon siya babad. Hindi po sa trabaho sa Kongreso. Yung mga members ng Quadcom, yung mga investigasyon, inaabot ng 1 o'clock in the morning. Imagine that. Ngayon nga, sa impeachment. Grabe yung trabaho ng mga members ng Congress. Tapos yung ibang members po, hindi man nagtatrabaho, patravel-travel lang. Sabay batiko sa ating Pangulo at kay Speaker. Binabatikos yung sub-sub sa trabaho. Ang nagbabatikos po, hindi man nagtatrabaho, mataas pa yung ratings ni Sara. Kaya po, lukuhan po. Diba? Nilinaw din ni Sandro Marcos na may mga exemption sa mga hindi makakadalo dahil sa sakit o opisyal na tungkulin sa labas ng batasan, habang ang pagpapalsipika ng attendance ay papatawan ng kaukulang parusa. Kasama rin sa panukala ang paglalathala ng attendance sa records ng mga mambabatas bilang bahagi ng pagsusulong ng transparency sa Kongreso. Ito si Sandro, anak siya ng presidente pero hindi abusado. ang makikita ninyo, pinalaking maayos ng kanyang mga magulang. Kaya malabo yung mga akusasyon nilang bangag. Bangag yung ating Pangulo, the first couple. Pero bakit na pa laki nila ng matino, ng maayos yung kanilang mga anak? Di ba? Kaya po yung yung hearing kanina, pinakinggan natin at na-take up yung addiction ng ating Pangulo. Mamaya iparinig ko sa inyo. Dito muna tayo sa sa issue ng sinusulong na no work no pay policy ni Sandro Marcos sa mga members ng Congress, pati mga senador. Yan yung kanyang final, House Bill number 7432, introduced by Honorable Ferdinand Alexander A. Marcos. Tapos may isa pang House Bill siya na final 7432 mandating ito pala 7443 abolishing the travel tax, an act abolishing the travel tax. Nagaling po si Sandro Marcos. Malamang susunod itong Pangulo. Yan sabi diyan. An act shall be known as Travel Tax Abolition Act of 2026. Yung prohibition po, sabi dyan, in refund. No government agency or private entity shall collect travel taxes upon the effectivity of this act for flights scheduled on or after the date of effectivity. The collecting authority shall immediately refund any previously paid travel taxes to passenger. So, laking tulong ito sa ating mga biyaheros para yung mga gustong mag-ikot-ikot sa ating bansa, malaya sila na mabisita yung mga tourist destination po. Di ba? Laking tulong ito sa mga local travelers natin. So, mabuhay si Sandro Marcos. O di, punta tayo mga kababayan doon sa sinasabi natin na subsob na pagtrabaho ng ating mga congressmen para dinigin yung mga members ng House Committee on Justice, yung impeachment complaint laban sa ating Pangulong Bongbong, yung sufficiency in substance. Ang sabi mga kababayan, bukas yung magiging botohan. Voting on the sufficiency of substance of the impeachment complaints versus PBBM will be done tomorrow, February 4. So kanina, pinapakinggan natin yung debate sa House Justice Committee. Ano yan tingin mo, Mr. Maravillas? Sa takbo ng mga discussions po, baka ma-reject pagdating doon sa sufficiency in substance, hindi pumasa. Yun ang takbo ng mga discussions kanina. Parinig ko sa inyo, mga kababayan, based doon sa mga articles of impeachment na nakalagay laban sa ating Pangulong Bongbong. So, pakinggan natin, mga kababayan, yung parte ng mga discussions, deliberations po kanina ng House Committee on Justice.
The border,
Thank
Madam
you.
Chair.
Before we proceed, we've heard a lot of opinions, comments, and even questions from the members with respect to the first offense. So it is the intention of the chair to limit the succeeding members who will be asking on this offense so that we can move to the next offense. Nonetheless, we recognize the Honorable SDML Lawrence Defensor.
Madam Chair, just a point of order on the way we proceed with the deliberations. Let's just address our manifestations as the complaint alleges. We don't have to interrogate the endorser. The Honorable Nisay is not the complainant. Let's just make manifestations and simply state the complaint alleges the following and state our manifestation. Thank you, Madam Chair.
We encourage the committee members to follow the suggestion of the Honorable SDML Lawrence Defensor. The Honorable Vice Chair Dumogan.
Thank you, Madam Chair. Pursuant to the instruction of the Chair, and has already been suggested, let me manifest that on ground one, there's no impeachable offense. We all know that there's no kidnapping. Second, the arrest was by virtue of an arrest warrant issued by the International Criminal Court because of an offense which had been allegedly committed when the Philippines was still a member of the ICC. And it was coursed through the Interpol. So, And let me point out, with all due respect, looking at all the complaints, there's actually no narration of facts. It just stated and went to the arguments. So, I am forced to, of course,
So makikita ninyo ang direksyon ng discussion po. Malabo yatang
respondent did not
ma-establish yung
commit
sufficiency
any betrayal
in substance.
of trust
Di
or
ba?
violation of the Constitution with respect to allegation number 1. I so submit.
Thank you, Vice Chair Dumogan. With that, the Chair wishes to move to the second offense. Please allow the Chair to read. Respondent is a drug addict whose condition impairs his judgment and leadership. This is anchored on the ground of culpable violation of the Constitution and betrayal of public trust. At this juncture, we elicit the manifestations, preferably manifestations, of the committee members with respect to its sufficiency in substance.
Madam Chair,
The Honorable Agbas is recognized.
with respect to allegation number 2, although the complaint claims the respondent is unfit to serve as president due to drug addiction, it fails to allege the ultimate facts showing how this alleged personal condition translated into any impeachable act. It does not narrate when the alleged use occurred, how it was committed, or how it affected any official function. It simply concludes that the respondent is unfit to serve without providing the facts required to demonstrate an impeachable offense. Further, no factual narration of an official decision, directive, or exercise of presidential power impaired by, connected to, or caused addiction.
So
That's all,
maulaan mo
Madam
na
Chair.
kung ano ang direksyon ng
Any
boto
other
nila.
member who wishes to make a manifestation?
Chair, may I be recognized?
The Honorable
Reject.
Barbers, and then De Lima, and then Suntay. One after the other. You are recognized, Honorable Barbers.
Thank you, Madam Chair. A manifestation. One of the grounds stated in the impeachment complaint filed by Attorney De Jesus and endorsed by Representative Lisay is the allegation that the respondent is a drug addict whose condition impairs his judgment and leadership. The complainant asserted that the respondent is unfit to serve as president due to drug addiction. He further alleged in his complaint that the respondent's refusal to submit to drug test conclusively demonstrate his disregard for transparency and accountability, and concluded that the respondent's silence and evasion confirmed the public suspicion and betrayed the trust of the nation he swore to serve. Madam Chair, let me point out that this assertion in the complaint was based solely on the alleged statements of the sister of the respondent, Senator Amy Marcos. The complainant attached copies of news articles containing reports on such statements of Senator Amy Marcos and forms part of the complaint. Under the
Mahina.
rules of procedure
News clips.
and for in impeachment proceedings, the requirement of sufficiency
Mahina ba?
is met if there is a recital of facts
Wala man.
constituting the offense charge and determinative of the jurisdiction of the committee. There is no evidence or authenticated records submitted
Malinaw.
by the complainant
Bagsak.
that will support his allegation that the respondent is actually using illegal drugs. The complainant did not even mention that he has personal knowledge of the drug addiction of the respondent. Such allegation of illegal drug use by respondent, which was reportedly stated by another person and not the one
Hearsay.
who filed the complaint, is mere hearsay and lack probative value. On the other assertions by complainant that the respondent is unfit to serve as president due to drug addiction, and that his refusal to submit to drug test are all speculative and without
Personal
any
view lang
factual
nila.
basis. I humbly submit,
Paniwala
Madam
lang
Chair,
nila.
that the ground for impeachment of the respondent on his alleged drug addiction that impairs his judgment and leadership is insufficient in substance.
Insufficient
Thank you,
in
Madam Chair.
substance. Oh,
The
malinaw.
manifestation of the
Reject.
Honorable Barbers is noted by the committee. The Honorable De Lima.
Thank you, Madam Chair. This is actually supplementary or complementary to the manifestation made or the opinion made by the Honorable Representative Barbers.
So,
The ultimate
pareha
legal
sila.
ground betrayal of public trust.
Hindi
The
kumbinsido.
specific allegation is alleged drug addiction of the president. And I would point out to certain sub-allegations and refute their insufficiency. Allegation number one, sub-allegation number one, there are serious accusations that PBBM is a drug addict. The offense alluded for this ground is drug addiction. Stating that there are accusations do not constitute factual allegations of the addiction. This ground presupposes that because PBBM is an addict or an alleged addict, he is unfit to be president. However, unfitness per se is not a ground for impeachment. And even when considered as constituting basis for betrayal of public trust, the statements in this ground do not sufficiently establish allegations on how specific presidential acts were impaired by PBBM's addiction, assuming the addiction to be true. Second sub-allegation, Senator Amy, the sister, admitted or alleged or announced that PBBM is a drug addict. Again, this is not a factual allegation, but a conclusion that because Senator Amy admitted or announced that PBBM is an addict, then he must be an addict. The most that can be made out of this ground is that there was betrayal of the public trust because of PBBM's failure to disclose his addiction. However, the recital of allegations to this ground is still insufficient in terms of showing the nexus. Kasi yun po importante. The nexus between the facts raised or alleged and betrayal of public trust. Public accusations of PBBM's addiction, Senator Imy's claim of PBBM's addiction, PBBM's refusal to submit to a drug test, and his silence on accusations of being an addict still do not constitute the factual allegations necessary to satisfy
pati
the
si
legal
Dilima
exercise and
kumampi.
the formulation of causes of action that assuming that they
Kumampi
were
sa
all
ating
true,
Pangulo.
they establish betrayal of trust. Another sub-allegation is the PBBM is a drug addict because he refuses to submit to a drug test. Again, this is a conclusion and not a factual allegation. Nasabi ko na rin po, that kind of an allegation is still insufficient. The fact that he refuses
Insufficient
to
in
submit to a drug
substance.
test. Another is by being silent. Sabi sa complaint, by being silent on his drug addiction, PBBM betrayed the public trust. For me, Madam Chair, this is a non sequitur conclusion and not a factual allegation, because the ground must not only state a categorical allegation that PBBM is a drug addict and that this impairs the performance of his mandate, but must also include a recital of the alleged acts, events, and incidents that support the same. How do they say, or how do they know, or why do they claim that it impairs his judgment? So that's again my view. Again, this second ground is insufficient in
Yung
substance.
first
I so
ground,
submit.
insufficient.
Thank you, Madam
Second
Chair.
ground, insufficient.
Manifestations
Bagsak.
noted by the committee. The Honorable Suntay.
Thank you, Madam Chair. On the second unfitness due to drug addiction, President Marcos is alleged to be a long-time user of illegal drugs. Drug use allegedly renders him manifestly unfit to discharge his presidential powers. The evidence presented were public statements attributed to Senator Amy Marcos, news articles, opinion commentaries, and medical articles on the effect of cocaine use. Thus, the legal theory asserted is that drug addiction impaired his judgment to discharge his presidential duties. However, this is a general conclusion because there was actually no narration of which of the presidential actions or judgment was impaired due to the alleged drug addiction. There was also no medical evidence presented, no drug test results. So the allegations were merely limited. The evidence of drug use were merely limited to media reporting and political statements made by Senator Amy Marcos. In Philippine impeachment jurisprudence, it has never recognized personal health allegations without proof of impeachable offense.
Correct.
Of the impeachable offense. And with regards to the second complaint, there were actually no general, there were actually no evidence, actual evidence presented to justify the allegations.
You're referring to the second offense?
Yes, with regards to the second offense.
Bagsak.
Thank you.
Madam Chair.
Honorable Garbin first, then Honorable Po. Honorable Garbin, you are recognized.
Thank you, Madam Chair. On the alleged drug addiction and moral unfitness, the key factual allegations by the complainants were the President is accused of being a long-time user of illegal drugs, including cocaine, and central reliance is placed on public statements by Senator Amy Marcos, the President's sister, alleging or acknowledging his alleged decades-long struggle with illegal drug use. And the legal framing of the complainant is that not framed on any criminal accusation, and it is used to support the moral unfitness, the impaired judgment, and the betrayal of public trust. The allegation that the President is a drug addict is insufficient in substance. It is unsupported
Bagsak
by
uli.
competent
Taga rito yan sa
evidence,
amin, kaibigan natin.
such as medical findings, sworn admissions, or official investigation on record, and rests largely on hearsay and public speculation. Absent verified and authoritative proof showing impairment in office or misconduct indirectly related to the exercise of presidential functions, such allegation cannot establish impeachable offense and should not be given weight, Madam Chair. Thank you.
The manifestation is noted. We will be
Reject.
limiting the manifestations and comments with respect to the second offense to the two last members. These are Kong Po and Kong Lorden Suwan. We encourage the other members to participate in the discussion of the succeeding offenses.
Madam Chair, can you add me for the second charge? Very short
All right.
manifestation.
Now we recognize the Honorable Po.
I'll make mine as quick as possible so that we can accommodate Kong Rufus. So with regards to my manifestation, Madam Chair, what we've established through everyone who has manifested ahead of me is that there's no record of illegal drug abuse. That is clear. What we know for a fact and what is actually on record is that on November 2021, there was a negative drug test that was attested to at St. Luke's. And further, on May 2024, there was actually a Senate hearing in which one drug analyst, Jeresa Reyes, and laboratory head Dr. Cecilia Lim confirmed that the President tested negative specifically for cocaine. So while there is no existing record of any drug abuse, the President has on 2 occasions proven that he is not a drug user. I submit that to the record so that we can make a objective decision on the substance of the second ground.
The manifestation is noted. The Honorable Lord Suwan.
Madam Chair, this is my manifestation. So there is an allegation in the complaint that there was an admission by Senator Amy Marcos that the President used drugs. However, this admission cannot be considered because of Rule 7, Section 17 of our own House rules regarding impeachment, which states that the rules of court apply superiorly. We should consider Rule 130, Section 28 of the Rules of Court regarding the res inter alios acta rule, which merely states that an act of one cannot prejudice another, meaning that the so-called admission of Senator Amy cannot prejudice the President, which means that the so-called admission has become irrelevant and cannot be considered as one of the bases for sustaining sufficiency in substance.
Our last committee members to comment on this are the Honorable Rodriguez and then Honorable Vice Chair Dumogan. We encourage the rest of the members to participate in deliberating the succeeding other offenses. The Honorable Rodriguez.
Thank you, Madam Chair. This is a clear example of not a recital of facts, but a conclusion of fact not based on any evidence. There is no evidence that the President is using drugs. Only statements of some persons. And then, this particular allegation, being a mere conclusion, does not connect to any of the 6 grounds of impeachable offenses. And so therefore, clearly, this particular second act complained of has certainly it's not sufficient in substance. Thank you, Madam Chair.
Thank you. The manifestation is noted. Vice Chair Dumogan.
Thank you, Madam Chair. In addition to what already been said, which I fully agree, reliance on newspaper clippings is not sufficient. The Supreme Court in Estrada versus Desierto had noted that newspaper reports cannot prove the truth of their contents and generally considered as hearsay. So, looking at all the arguments, because as we said, there's no narration of facts, the arguments will not somewhat come out with a legal conclusion that the President violated a culpable violation of the Constitution, being a drug addict.
Thank you, Vice Chair Dumogan. The Honorable Padiernos will be the last speaker on the second offense.
Madam Chair, I was already preparing for the next one, but I just wanted to join the Honorable Barbers in stating that the impeachment cannot proceed on rumor or hearsay. So that is very clear under the rules. And as mentioned by the Honorable Suwan, the res inter alios acta rule apply. So, and in addition, personal allegations unsupported by medical or judicial findings do not constitute the impeachable offense of betrayal of public trust. That's it, Madam Chair. Thank you.
Reject 1 and 2 articles of impeachment, insufficient in substance, walang sustansya. Kung saan niluto mga kababayan, matabang. Tama? O yung pangatlo na articles of impeachment, pakinggan natin.
It's our discussion on the second offense. Now we are moving to the third offense. Please let the chair read. Respondent failed to veto unprogrammed appropriations and other unconstitutional provisions of the General Appropriations Bill for 2023, 24, 25, and 26. The same is anchored under either some or all of the following grounds: graft and corruption, culpable violation of the Constitution, and betrayal of public trust. At this juncture, we elicit the opinion, comment, reaction of the members to this allegation.
Madam Chair.
The Honorable Ambel Amante.
Yes, about the unprogrammed funds. Actually, ma'am, since 1989, ay may mga unprogrammed funds na po. Even during the term of President Corazon Aquino. At ngayon, Madam Chair, kinikilala din ito ng ating gobyerno. Actually, yung unprogrammed funds ay nasa General Appropriation Act yan. At matatagpuan yan sa unprogrammed appropriation or sa under ng Special Purpose Fund. So, mahalaga din ito, Madam Chair, sa ating Pangulo, if just in case na magkaroon ng mga calamities or unforeseen expenditures. Halimbawa, may mga nasirang kalsada, nasirang tulay, diyan pwedeng kunin ng ating Pangulo yung pagpapagawa doon sa mga naturang mga infrastructure project. Dahil baka mamaya, halimbawa, masira halimbawa ang South Luzon Expressway just because of the earthquake, hindi man pwedeng aantayin yung susunod na taon para maipagawa ito dahil maraming nakikinabang. So, ayun lamang po, Madam Chair, yung ating komento about the unprogrammed funds. At I don't think na kinakailangan ibito ito ng ating mahal na Pangulong Bongbong Marcos.
Reject.
Thank you. The manifestation
Madaling
is noted.
sabi,
Any
yung
other comment?
Pangatlong article.
The Honorable Eming Pascual.
Yes, Madam Chair, the inclusion of unprogrammed appropriations in the national budget has been practiced since 1989 up to the present.
Panahon pa pala ni
Since the
Cory.
administration of President Aquino up to the present administration of President Marcos, the inclusion of unprogrammed appropriations in the national budget has been accepted. It's been already become a matter of tradition and public policy to include unprogrammed appropriations in the national budget. Ang hindi pagbeto ng Pangulong Marcos sa kabuuan unprogrammed appropriations ay hindi paglabag sa anumang provisyon ng saligang batas. Hindi rin siya nagkasala sa taong bayan. Binigyan lang ng Pangulo ng pagpapahalaga yung nagdaang mga administrasyon. Imagine 7 administrations from Cory Aquino to former President Ramos, former President Estrada, former President GMA, Pinoy Aquino, and Duterte administration, itinuloy lang po ito ng Pangulo.
Pati
And
bata
lastly,
Siligong,
once the
may
unprogrammed appropriations is included and approved in the national budget, President Marcos is not the one implementing it, but the agency concerned like the DPWH. Yun lang po. Thank you, Madam Chair.
Thank you, Honorable Pascual.
Reject.
Any other member who wish to comment on this?
Madam Chair.
The Honorable Ere, and then Honorable Acosta, and then Honorable De Lima, one after the other. And then Honorable Rodriguez. Honorable Ortiz, you are recognized.
Madam Chair, I think the issue of the 2023, 2024, and 2025 budget and the program appropriations and other items that has been questioned even by the investigation of the Blue Ribbon Committee is a very complicated matter. Sa tingin ko po ay walang personal na kaalaman yung complainant tungkol dito. Kaya po hindi po niya naipresenta ng maayos yung
maging seryosi pala.
complaint na ito at sa tingin ko po
Hindi
ay
maayos.
hindi niya maiugnay batayan lamang yung mga news articles.
So,
Kaya sa tingin ko po
anti-Marcos
ay
yan, pero
sapat
hindi conforme
yung
doon.
substance ng
Walang substance.
complaint na ito. Salamat po.
Thank you,
Anti-Marcos
Honorable
yan si
Alicia.
Rize.
Next is the Honorable Acosta.
Thank you,
Reject
Madam
po
Chair. Just 2 points.
sa
First
substance.
is on the veto power of the President.
Madam Chair, that the power of the President to veto bill or specific items in an appropriations bill under Article 6, Section 27 is a discretionary power, not a mandatory duty. Jurisprudence dictates in that landmark case of Bengzon versus Bjillon establishes that the President cannot be compelled to exercise a veto. Therefore, Madam Chair, a failure to veto cannot be a definition or a culpable violation of the Constitution. Second is on the attachment on paragraph 25, on that case of Pimentel et al. Versus House of Representatives, Colmenares versus Executive Secretary, GR numbers 274778, where the Supreme Court declared part of the law unconstitutional, does not automatically mean that the President is culpably violated the Constitution by signing it. Thank you.
Reject.
The station of the Honorable Acosta is noted by the committee. Next is the Honorable De Lima.
Thank you, Madam Chair. As to this third ground, the specific ground of failure to veto unprogrammed appropriations and other provisions of the 2023, 2024, and 2026 GAA, as allegedly constituting betrayal of public trust. My view, again, is that these are insufficient, or this ground is insufficient in substance.
Honorable Rodriguez, then Honorable Chua, then Honorable SDML Defensor.
Thank you, Madam Chair. Manifestation very short. Again, this particular third act does not constitute, it does not have comply with the requirement of sufficiency in substance, because the President has that discretion to veto or not. If it's veto, that's the end. You try to have it again, probably convince the President the next time to veto. If it's veto, the only solution is not even the committee. It goes back to Congress to override it. And the problem here really is the connection and the support to the allegation that President BBM committed betrayal of public trust. Of all the grounds, in the 6 grounds, the 4 are very clear. The first ground is culpable violation of the Constitution. You have to show which section of the Constitution is violated. Number 2, treason. That's Article 210 of the Revised Penal Code. Committed only in times of war. Third is the a case of bribery. That's 114 of the Revised Penal Code, direct bribery, knowingly receiving. And then the fifth is other high crimes. American have no decision on this, but American laws, it is such gravity that it involves already its effect on the nation by these officials. That betrayal of public trust is a matter of public policy to be done by Congress. We will be the one to decide what is betrayal of public trust. And to me, there is a failure of the narration of facts to say that the failure to veto of unprogrammed appropriations will be a betrayal of public trust. That's so far from this title of this act to the constitutional requirement that there should be betrayal of public trust. So therefore, that is my manifestation. Again, no substance in this case.
Walang substance.
Joel Chua.
Thank you, Madam Chair. Madam Chair, the third issue relies solely on the failure of the President to veto the unprogrammed appropriation. So yung pag-veto lamang po ang kino-question niya po dito. But we know for the fact that the veto power is the exclusive prerogative and power of the President. Not even the President, not only the President, but all local government executive. Maski po sa mayor, governor, they all have this veto power, and that is exclusive. Hindi po ito mandatory on them, pwede po nilang i-veto kung ano pong item sa budget. So that is their prerogative. Kaya hindi rin po nakastate dito sa fact na to kung bakit ito, kung ano pong crime ang na-violate ng Presidente sa kanyang failure sa pagveto ng nasabing unprogrammed.
So, bagsak. Uli, bagsak.
That's why,
Fourth offense.
Please allow the chair to read. Respondent benefited from kickbacks arising from budget insertions and ghost flood control projects. At this juncture, the chair elicits the comment, opinion, and reaction of the committee members.
Madam Chair.
Si Abante, baka mag-walk out daw uli. Hindi daw siya mag-walk
Kaya
out.
kasama na rin ako dito. Anyway, ito pong fourth
Kapag nag-walk out.
allegation. Isa lang sabihin ko dito. Nakalagay po sa ating rules, if it finds that sufficient grounds for impeachment do not exist, the committee shall dismiss the complaint and submit
Dismissal
the
na.
report required hereunder. Ito po, it does not actually exist because everything that is said here is hearsay. Yun lang po.
Thank you. The Honorable Rodriguez.
Hearsay,
Madam Chair,
mga kababayan,
in this
gawa-gawang
fourth
kwento.
act alleged, it is clearly based on the fourth ground of impeachment, which is graft and corruption. The Supreme Court, in the case of Francisco versus House of Representatives, clearly already said that this is defined under the Republic Act 3019, which is the anti-graft code, the anti-graft law, which provides Section 3B and C. These are the main, if this is an allegation of a public official who receives kickbacks and from ghost projects and so forth, it should be under this. And it is clear, Madam Chair, we have to therefore go whether there's a recital of facts in relation to, Madam Chair, Section 3B and C. And here we go. This is now what it says, Madam Chair. It says Section 3A, knowingly, deliberately, requesting and receiving money because of an important project or permit to be issued by the person. There is no allegation here, Madam Chair, that the President
Bagsak uli.
requested, that the President received money because he has a permit or contract to give. That is precisely what is stated here under Section 3A.
Alam na ang boto ko.
Directly requesting or
Reject.
receiving any gift, present, share, percentage, or benefit for himself or for any other person in connection with any transaction or contract between the government and that party. The second one, 3C, also is directly or indirectly requesting or receiving any gift and so forth for himself and another in a manner or capacity that has secured or obtained this particular permit. So there are only two. There are only two provisions under Republic Act 3019, wherein, according to the Supreme Court, the fourth ground could be anchored upon, and there is none. There is no allegation here. Now, there is a statement here about Ako Bicol party list. This is a narration of fact, the recital of fact. However, the problem with this fact is that it was delivered to respondents' allies. If you can look at this, not to the President. Now, this is an impeachment, proposed impeachment of the President. And then attached copies of the video expose. Madam Chair, the video expose is abroad, wherein we, in the later part, will have to hear
Yung kay
this
Saldi ko po
particular
yan.
person has to be present. Otherwise, it's a piece of paper and a piece of video that is not allowed to be introduced in any proceeding.
Inadmissible. Madaling sabi.
We have to give the chance to the respondent to question always. This is the cross-examination. This is the time to also provide the respondent the time to question, cross-examine the person who said that the money was given and he is not in this country. He's either in Portugal or Sweden.
Saldi
So
ko po.
therefore, Madam Chair, once again, the fourth
Bagsak.
ground, which is respondent engaged in graft and corruption through kickbacks and ghost projects, there is no recital of facts that will constitute the violation of Republic Act 3019. Thank you, Madam Chair.
On graft and corruption. And of course, we recognize also the needed authenticity about the video of this expose. The Honorable Vice Chair Dan.
Thank you, Madam Chair. Yes, on allegation number 4, respondent engaged in graft in corruption through kickbacks and ghost projects. The allegations which seem to justify the said charge are contained in paragraphs 27 up to 32. Reading all these paragraphs, they do not contain the narration of facts that will pinpoint to the President, that will somewhat allude an illegal violation which is tantamount to graft in corruption. What
Si Laila de Lima.
Specific allegation that allegedly the president benefited from kickbacks arising from budget insertions and ghost flood control projects, with 4 sub-allegations. 1, PBBM orchestrated insertion in GAA for kickbacks. I agree with the Honorable Acosta that it lacks specificity as to what, how, and when.
Reject
making this a
din kay
conclusion
Dilima.
rather than a factual allegation. Of factual allegations.
Falsity.
Again, this is insufficient.
Insufficient.
Thank you, Honorable De Lima. Our last speaker on the 4th offense is the Honorable King Coliantes.
Madam Chair, I'd just like to manifest my support for all of the comments said by our dear colleagues. But really, the question right now here is, are these just conclusions made by the complainant, or are these really based on fact? Remember, we have to go back to the verification, which says that all of his allegations must be based on personal knowledge. Does the complainant have personal knowledge? Was he there when these alleged transactions happened?
Ayun, bagsak.
Does he have any
Tama.
basis based on authentic records to say that money was transferred, money was provided to the president? I doubt it. So I think based on what is written on the complaint, it is insufficient as a ground for impeachment.
The
The
last.
5th offense.
Fifth.
Please allow the chair to read. Respondent created the ICI
Lalo na dito,
to
baseless ito.
shield corrupt allies. So, this is the offense, and the same
Basurang
is anchored
impeachment
under
talaga po.
for all of the following: graft and
Reject.
corruption, culpable violation of constitution, and betrayal of public trust. At this juncture, we elicit the comments and opinions of the committee members. First, we recognize the Honorable SDML Lawrence Defensor.
Thank you, Madam Chair. I would have to speak. I'm compelled to speak for the membership of the ICI regarding this allegation that it was created to shield corrupt allies. Madam Chairman, the appointment and participation of the members of the ICI, particularly Secretary Rogelio Singson, whose integrity and reputation speaks of good governance, contravenes the allegations by this impeachment complaint head-on. Hindi ka maglalagay ng mga taong naging ehemplo ng mabuting patakaran
Correct.
at pamahalaan kung ang balak ay pagtakpan ang korupsyon. So the membership itself of ICI, a presiding justice of the Court of Appeals, an SGV partner who is a partner on audit, and someone like Rogelio Singson, who is a model for good governance, clearly runs contravene against this allegation in the creation of the ICI. Thank you, Madam Chair.
Thank you, Honorable
Malinaw.
Lawrence Defensor. The Honorable Franz Legaspi is recognized.
Thank you, Madam Chair. I'd just like to give a very short manifestation to take note of the evidence or the annexes presented, the evidence in the annexes presented. For me, and this is a general observation as well with the earlier topics, but in particular for this ground, there are a lot of evidences the sources are only media outlets, news sources, and I think this was generally already noted by our members of this committee. But in this particular ground, these articles are, I think, 4 opinion columns, mostly predicated on the opinions of certain personalities, certain characters. And I think in relation to the particular ground that the complaint wishes to state, I believe I think it's clear the betrayal of public trust with regard to the creation, or rather the ICI's creation, somehow affecting or resulting in a loss of public trust, which would, in this case, be a ground to impeach the president. I think it's very clear on that part that the evidence presented is not directly related to that particular ground, and also it's also vague with regard to the metrics or how it could match or say that there was a betrayal of public trust or that the trust ratings are affected by the creation of the ICI. So that's my humble submission, Madam Chair. For me, I think this is just based on this ground is already insufficient in substance as well. So thank you, Madam Chair.
Thank you, Honorable Legaspi. We are on the last offense. This is the allegation that the creation of the ICI is used to shield the allies of the impeachable official. The Honorable Vice Chair Dumogan is recognized.
Thank you, Madam Chair. Again, it appears that this is one of an allegation that is not at all supported by narration of facts. In fact, as we all know, aside from what had already been stated, the integrity and competence of the members of the ICI appointed can disprove this fact. Second, they have investigated all those that had come to their attention related to corrupt implementation of projects, which clearly disprove the allegation that it has been created to shield certain allies in government. So it's far, far away from establishing a legal violation which is considered as willful violation of the Constitution as an impeachable offense. Your Honor, thank you, Madam Chair.
Thank you, Vice Chair Dumogan. Any other comment or manifestation from the members? The Honorable Po.
Madam Chair, the creation of an anti-corruption body in and of itself is not an impeachable offense. Now, there's an assumption in this grounds that it was used for shielding. However, what we actually have evidence of in terms of the ICI's actions is that its investigation included both allies and non-allies alike. Its recommendations also had both allies and non-allies alike. And if we're going to discuss further, I would caution our colleagues on finding substance in this, because we do not want to discourage future anti-corruption efforts. We don't want to discourage future transparency efforts. What we're discussing is the willful violation of the Constitution. But what we have here on record is the willful act of the President for transparency and accountability. That's what we have objective fact on. So I just want to make sure that we are not dissuading efforts for transparency and accountability within our government by finding substance in this.
Madam Chair.
Thank you. The Honorable Rodriguez.
Madam Chair, I take exception to this particular ground for impeachment. I personally know a former Secretary of Public Works and Highways, Rogelio Babe Singson. I was already Congressman of the 2nd District of Cagayan de Oro. And he often comes to Cagayan de Oro to be able to look at projects. And during his time, and even up to now, there are no ghost projects in Cagayan de Oro 2nd District, nor any substandard project. Now, he would not accepted if this is a shield. And he would not have continued until he, because of health reasons, has to therefore resign. But during the term that he was there, together with the SGV representative and former Presiding Justice Reyes, It was clear that they were able to invite and get documents. And some have already been recommended for filing. If this were a shield, then there would have been no action of the ICI. But there were many already given to the Ombudsman for investigation and preliminary investigation. So therefore, this is something that it does not give justice to those who have already been appointed and had worked on this particular ICI. And so therefore, I personally know the former secretary, and I was very happy that despite the fact that, he has been retired, he's retired, he took the job because he believed that the ICI can make a difference in stopping all of this flood control mess and then be able to send the proper cases and documents to the Ombudsman, which is the jurisdiction over cases of graft and corruption and plunder. Thank you very much, Madam Chair.
Thank you. Next is the Honorable Lord Suwan.
Madam Chair, the body of the complaint does not contain any express provision in the ICI's charter that limits investigations only to political opponents, nor does it contain any instances of limiting of any instances or policy or rule exempting allies. In fact, I remember that even the president's son was summoned to the ICI. Nor does the complaint state any rule by the ICI which bars or obstructs any investigation against allies. And I have seen several instances in which supposed allies of the president were summoned to the ICI. To emphasize, the president has the authority to create ad hoc investigative bodies to ensure faithful execution of our laws. And saying so, the ICI is only a recommendatory and fact-finding body. Furthermore, allegations of political targeting are only speculative, and bad faith cannot be presumed. They must be proven with particularity.
The Honorable Garbin.
Thank you, Madam Chair. The establishment of such body like the ICI falls within the President's executive and administrative discretion, which we have constantly regarded as political question and which is outside the ambit of this honorable body. Be that as it may, the complaint likewise does not allege ultimate facts showing abuse, unlawful purpose, or concrete acts of favoritism directly attributable to the President. Absent specific evidence demonstrating selective enforcement or deliberate shielding of particular individuals through identifiable presidential acts, the allegations, Madam Chair, remains conclusory and cannot sustain a finding of an impeachable offense.
Thank you. Any other member?
Madam Chair,
The Honorable Abante.
if I would like to give my own manifestation on this.
Is this on the fifth offense? Is that on the fifth offense?
Yes, yes.
You may proceed, Honorable Abante.
Although the ICI should have been given more powers to investigate and to subpoena, na hindi po nangyari. Ito pong si Attorney Andre De Jesus. Hindi ko alam kung anong klaseng abogado ito. Pero nakakahiya naman doon sa members ng ICI na magaling mag-imbestiga at para bang sila din po ay nagkasala din at nagkamali ng taong bayan. I just would like to say na walang kwenta po itong sinasabing itong tinatawag natin na respondent created the ICI to trap allies. Siguro po, kung siya ang pursue niya yun. The thing is this, no ha? Palagay ko talagang wala na pong sufficient grounds tong impeachment na ito eh. Dapat talaga ibasura na ho natin ito sa lalong madaling panahon. Maraming salamat po, Madam Chair.
Alam na ninyo ang destiny. Basura yun. Hindi pa umabot. Insufficient. Mga kababayan, most of them, if not all, wala akong narinig na pumabor. So bukas yung butuhan, kung sufficient in substance, mga kababayan ba? Sufficient in form na nagbutuhan na, okay doon. Pero sa substance po, bagsak. Alam na, ibabasura. Yun ang mangyayari sa butuhan bukas. Basura man talaga yun, mga kababayan. Panggulo lang sa ating Pangulong Bongbong.